Former President Donald Trump has been indicted for a third time for his role in attempting to overturn the results of the 2020 election. Trump claims
it's a political witch hunt,
and many of his supporters say the charges are politically motivated. But the decisions to indict Trump haven't come from prosecutors. Those decisions have been made by grand juries made up of ordinary citizens. Here's how a federal prosecutor actually secures an indictment from a grand jury.
An indictment is a charging document. It is the document that really gets a criminal case started. Most important thing to know is that the prosecutors draft an indictment, but for it to get approved, it must be approved by a grand jury.
Professor Mushtaq Gunja taught at Georgetown Law School and was a former federal prosecutor.
There are two principal ways that a defendant can get charged in the United States. The first, more traditional way is through the indictment process through a grand jury.
Then there's prosecution by information, in which prosecutors draft criminal complaints and take them straight to a judge for approval.
Most prosecutors, when they can, will prefer to use indictment and grand jury. And that's because if a case is charged by indictment or by grand jury, then a defendant does not receive this preliminary hearing where they get to go to court and test the evidence.
Indictments are commonly used to charge federal felonies, especially those that can lead to more than 1 year of imprisonment or even a death penalty. Different from a trial jury that delivers a guilty or not guilty verdict during a criminal trial, a grand jury determines whether there is a high probability a crime was committed and whether the accused should be tried. What makes the indictment process unique is that it's one-sided. The grand jury votes on indictment after questioning the witnesses and examining the evidence presented by the prosecutors, without the presence of the accused.
And so, in many cases, actually, when I charged cases by criminal complaint initially, I would often follow that up by taking the case to the grand jury and having an indictment issued.
In Trump's second indictment, Special Counsel Jack Smith alleged Trump broke national security laws by mishandling classified documents. Because Smith claimed felony violations of federal laws, he must acquire indictment to put Trump on trial. The classified documents were found at Trump's Mar-a-Largo resort, which is covered by the Southern District of Florida. Under federal law, the district judge must form a 16 to 23-member grand jury from a group of randomly drawn citizens. The jury then assumed its duty. Sometimes it could take months before the jurors approved the indictment with a minimum of 12 votes. Once the indictment was filed, Trump was arraigned and had to appear in court to plead guilty or not guilty to the charges. He pled not guilty in each of his previous indictments. But despite its purpose of preventing unwarranted prosecutions, the grand jury system has been under increasing criticism.
It has been seen to be too easy for prosecutors to be able to have a grand jury indict. It's sometimes said that a good prosecutor can get a grand jury to indict a ham sandwich. But I think it's slightly overstated because the prosecutors probably are not bringing the worst cases to them because of the mere existence of the grand jury. And the grand jury's job is not to evaluate whether the defendant definitively did it, just whether they probably did it. I really think the grand jury system is incredibly important. I think that it really provides a level of protection for criminal defendants that is crucial.